Augusta Woods versus Paul Reedy and Nella Reedy. Well,
Daniel
Paul Reedy.
Landman for the plaintiff. Mr. Reedy was present. There he is.
Welcome back to another courtroom breakdown, where real people, real financial struggles, and real legal consequences collide. Today's hearing may look like a routine landlord-tenant docket, but do not let that fool you. Within the next several minutes, you are going to see Judge Simpson navigate a series of rent disputes that all have one thing in common. Every defendant has a different explanation for falling behind, yet the law requires the court to separate hardship from legal responsibility. As this session unfolds, pay close attention to how the judge changes his approach depending on the facts presented. Sometimes he pushes for immediate payments, other times he pauses the case to gather more evidence. And in one particularly interesting dispute, he orders rent to be paid directly into court instead of to the landlord, a legal tool known as escrow that often surprises viewers who are unfamiliar with housing law. Notice something else as well. Judge Simpson rarely interrupts without a reason. He allows people to explain themselves, but he also knows exactly when a story stops being legally relevant and when documentation becomes more important than emotion. That balance is one of the biggest reasons these hearings are so fascinating to watch. The first defendant has appeared before this court before, and even the judge jokingly acknowledges that fact. Behind the humor, however, is a serious issue. Repeated promises to catch up on rent eventually lose credibility unless they are backed by actual payments. Excuses may explain why someone fell behind, but they do not erase the debt.
Just
Needs
easy.
to unmute.
Okay. Mr. Reedy, we got to quit meeting like this. All right.
Welcome back. Yeah.
All
Sorry.
right. No, it's all right. What is plaintiff's claim?
Your Honor, plaintiff is showing rent to retain of $373.83 and costs are $218. So the grand total is $591.83.
All right, Mr. Reedy, how are we going to get that done?
Okay. I've been trying to get it straightened up. Was close to getting it straightened up. I paid $1,100 on the 3rd. Then my truck broke down. I bought a used truck, and the warranty that I purchased, of course, didn't cover corrosion for my exhaust manifolds. So that's in the shop getting fixed. I'm like, man, it was $288, and then the late fee, and then the court fee was like, oh my gosh. Anyways, I called the lawyer's office yesterday, and they said they didn't see my name, so I was hoping it was like a dismissal or something. But I'm just trying to find out if there's any way I could work with them and get everything totally paid on the 3rd when I get my check. I've been saying that, but then it's like something happens. I don't owe a ton. And I'm close to being good, but man.
No, I got you. Let me ask you this. Between now and next Friday, how much do you think you can pay?
I hate to say that I can pay it and not be able to pay it, but I'm going to do whatever you say to do, you know.
Well, I'm asking you, how much do you think you can pay between now and then? You're not that far.
I'm not sure. Hopefully at least a couple $100. I know it's more than that, but
what I'll do is I'll just put a couple hundred here, somewhere by the 19th, and I understand what you're telling me. I'll adjourn this out to September 19th, 2025 at
3 p.m.
3 p.m. All right, that's an in-person hearing. And then contact the attorney's office or the management and see what you can work out.
Judge Simpson recognizes something many viewers may overlook. This hearing is not about punishing someone for having financial problems. It is about determining whether there is a realistic path toward resolving the debt. Mr. Ray admits he has fallen behind, explains the unexpected truck repair, and avoids making promises he cannot confidently keep. Ironically, that hesitation may make him appear more credible than someone offering unrealistic guarantees. The judge responds by setting a specific payment expectation and another court date instead of issuing an immediate judgment. That gives the tenant one final opportunity to demonstrate progress before stronger legal remedies become appropriate. Courts frequently appreciate honest communication, but honesty alone never satisfies unpaid rent. Action must eventually follow the explanation. What do you think? Should repeated financial setbacks earn additional patience from the court, or does there come a point where landlords deserve immediate enforcement regardless of personal hardship involved?
between now
Okay, I
and then.
appreciate you. I appreciate you, sir. Thank you very much.
All right, take care, sir.
Have a good day.
You too. Arbor Meadows versus Thomas Miller.
Daniel Landman for the plaintiff. I do see Mr. Miller being in the Zoom
Hey.
meeting.
Hello, Your Honor.
Hello, Mr. Miller. Can you turn on your camera down there, or?
I'm here in the court learning the laptop here. My phone
Okay,
was
it's all right.
Oh, there he
We
is.
got you. There
my
we
my
are.
phone wasn't connecting. It connected, kicked me out, connected, kicked me out. So I figured I'd
No,
call the number and get up here.
it's okay. We got the message that you were having problems and you're coming down. So appreciate you doing that. All right, how much is owing on this?
Your Honor, my client's books and records reflect a balance of $2,202.60, costs of $175 for a grand total of $2,377.60.
Your
All
Honor, that would be as of October 1st. It's not October 1st yet, so that next month is not due.
Let me check that, Your
Hold
Honor.
on a second.
I only owe for September.
Hold on, Mr. Miller.
Yes.
Your Honor, the ledger is reflecting that that's owed through September. It does not include October.
No. I'm
All
only
right.
1 month behind.
You're 1 month behind for,
September, sir.
you think you paid through August?
I would have to jump into my receipts, but I'm only expecting $1,123.73, I believe.
That, Your Honor, was
And that's
the
what
amount in August without
Your Honor,
including September's run.
I have the court paper here of the number is 1,123 on the court paper. It's not
I
2,000.
gotcha. No, and those court papers, let me just double check, would have been filed with your August balance because those were filed in August. And now September's due. All
I
right.
can't
Let me ask
argue
you-
without my records, without the receipts. So
Okay.
I was
So-
only
Between now and next week, how much can you pay?
I have 300 in my pocket. I've had to pay everything else due to medical problems between my wife and myself. I've been unable to work. And she can't work because they won't hire her.
All right.
But I have 3 degenerative discs, so there's times that I can't even walk, Your Honor. And I've been, this last year has been really bad. I've been working with some dermatologists, rheumatologists, and all this to get me to where I can manage. I've got psoriatic arthritis, which is also psoriasis. So it's really
Got
hard sometimes. This is why you see me a lot, is because sometimes I can't hold up to my responsibilities, but it normally doesn't take me very long to come back.
Okay. So
Um,
here's what I need you to do. And let's see what we can work out. Pay the 300 to your landlord today. And then I'll adjourn this out to September 19th at 3 p.m. That'll be an in-person hearing. So you need to come down to the courthouse like you did today, but you get to come into the courtroom. Okay?
yes, sir. Thank you, Your Honor.
All right. We'll see what we can do. All right. Take care.
This exchange highlights one of the toughest realities in housing court. Medical emergencies can dramatically reduce a person's ability to earn income, yet lease obligations usually continue unless another legal arrangement exists. Judge Simpson listens carefully as Mr. Miller explains chronic health issues affecting both himself and his wife. Rather than dismissing those concerns, the judge acknowledges them while still requiring immediate good faith action through a $300 payment. That requirement serves an important legal purpose. It demonstrates whether the tenant is actively trying to resolve the debt instead of simply delaying the inevitable. Notice how the judge balances empathy with accountability instead of choosing one over the other. Neither side receives everything they want today. Instead, both receive another opportunity before the next hearing. If you were facing similar medical challenges, what would you expect a court to do differently while remaining fair to the landlord as well?
Clark Road Family Dividend Housing versus the Jerry Baker.
It's Dejanay Baker, Your Honor.
Say it again.
Dejanay.
Dejanay. Okay, I get it right today, but I'll mess it up next time, I
It's
guess.
okay.
All right.
It's hard.
Okay. All
Good
right.
morning.
Counsel?
Good morning, Your Honor. Attorney Samantha Sprague, 1931, appearing on behalf of the plaintiff.
All right. And what is plaintiff's claim in this case?
Yes, Your Honor, we do show that currently there is past due rent in the amount of $2,779.23, along with court costs of $239.40, for a total due owing of $3,018.63.
All right. And Mr. Baker, how are you intending on getting that paid?
Your Honor, at the moment, I do not have the money to pay that.
Okay, have you sought out any assistance at all?
I have. Your Honor, thank you for allowing me to speak first and foremost. I'd like to explain why I stopped paying my rent in July. It was not made lightly. It was due to my landlord's repeated failure to uphold their responsibilities under the lease and maintain the premises in a livable condition. There were even problems prior to my move-in. The original lease that I signed on date of January 24th, but the complex changed that date to January 31st. Without my consent, even with the new date, I was still required to pay a proration rate of $550. On top of that, I didn't sign an official lease until March 6th, which caused confusion about my rights and my obligations. Most recently, I came home to find a leak in my ceiling that caused a large hole in my apartment. The water damaged my new sectional, my television, and resulted in the death of my pet gerbil. The hole is still present, and the leak was never properly resolved. The situation made my apartment an unlivable.
Did you tell the landlord you had a leak?
Yes, I did. I had called them that same night, and the maintenance director came to my apartment that night and discussed with me a few more issues that was going on in the apartment complex, as far as the shooting that had just happened the day before, as well as other problems with tenants having the water leaks in their apartments. It's black mold growing in the building. There is a tenants union that's trying to pursue a civil lawsuit against Huron Vista about the problems that
All right, here's what I'm gonna do. I'm gonna stop you right there. I'm gonna adjourn this out to September 19, 2025 at 3 p.m. That's an in-person hearing. You'll need to appear. I will reserve from this date the issue of escrow in this matter. You'll need to file a written answer with the court detailing what your complaints are. You'll need to do that by September 18, 2025. You need to send a copy to the attorneys for your landlord.
Okay.
All right, we'll see you next week in person. Thank you.
No problem.
This hearing takes a significant turn because the dispute is no longer just about unpaid rent. Ms. Baker introduces allegations of water damage, an unsafe living environment, black mold, and property damage that allegedly includes destroyed belongings and the loss of a pet. Those claims, if supported by evidence, can materially affect how the court evaluates the case. Judge Simpson wisely avoids deciding the issue based solely on verbal statements during a brief hearing. Instead, he orders a written answer detailing every complaint and requires that the landlord's attorney receive a copy. That protects both sides and creates a documented record before the next appearance. Evidence, photographs, maintenance requests, and written communication often become far more persuasive than emotional testimony alone. Do you think tenants should withhold rent when serious repair issues remain unresolved, or should they always continue paying until a judge rules otherwise?
Valley Ranch versus Sharia Caldwell.
Hi, Your Honor.
Hello. What's your name?
Sharia Caldwell.
This is very unusual. Ma'am, do you think you paid your rent?
So what happened in my situation was for the month of August, I tried to go into the office and give them the cashier's check, but they told me that they were no longer accepting cashier's checks for whatever reasons within our company policy that had changed. So at that point, it was mid-August they have filed in court. And so the late fees, the court fees was an additional almost $700.
No, I got you. I got you.
Yeah,
No, I'm trying to figure out, usually these attorneys are here. And so I'm giving them some latitude. Can we call their office? All right, ma'am, I'm going to stand in recess a bit and then I'll come right back. You're all I've got left, but I don't know where the other side is. Okay.
right. Thank you, Your Honor.
Thank you. And the court does recall the case of Valley Ranch versus Caldwell.
Thank you, Your Honor. Rachel Dornbush, Palace Law, on behalf of the plaintiff.
What is plaintiff's claim in this case?
And Your Honor, we have a total due with court costs of $4,954.36.
All right. And Ms. Caldwell, how are you intending on getting that paid?
Hi, Your Honor. So I was mentioning before that I tried to come into the office to pay with the cashier's check for the month of August. However, I was told that they no longer accept the cashier's check. And that when you try to pay online using your debit card, it was an additional $100 and something that I didn't have. So what happened was, after mid-August, once they said that they wasn't accepting my cashier's check, the court had the fees and the late fees, the court fees had already been filed and added.
This case immediately stands out because the dispute centers on an attempted payment rather than an outright refusal to pay. According to Ms. Caldwell, she arrived with a cashier's check ready to satisfy her rent, only to learn that the property's payment policy had changed. If that sequence is accurate, the legal picture becomes much more complicated. A court must determine whether the tenant genuinely attempted to meet her obligation or whether the payment failure ultimately remained her responsibility. Judge Simpson does not immediately accept either version as fact. Instead, he carefully listens before deciding what additional information is necessary. That patience is one reason these hearings are so instructive. Good judges avoid rushing to conclusions simply because one story sounds convincing. Every important claim deserves verification. Small details, like how payment was offered, can completely change the direction of a landlord-tenant dispute in court proceedings.
So at that point, I couldn't afford that piece of it. In between time, in additional, what was happening as well is that the second bedroom, we've been having issues to where it's been flooding, like the entire bedroom. So now I believe there is mold growing around the baseboards of the second bedroom. So right now, my goal was to work with the property management company because of the mold from the issues of, I believe it's like a foundational issue because we're kind of like right off the pond area. So when it rains and we're garden level, it's the whole entire second bedroom gets flooded out. So at this point, I wanted to work with the property management company to see what the options were.
All right, here's what I'm going to do. I'm going to order that you, if you've got what you claim are repair issues, I need a written answer to the court by September 18th, next Thursday, and you need to send a copy to plaintiff's counsel.
Understood.
Thank
All
you,
right.
Your Honor. And just so the court's aware, and when I spoke with my client, Your Honor, the person who I spoke with was unaware of the issue that Ms. Caldwell raised, but it looks like she did submit some maintenance work orders. Sounds like she informed the leasing consultant that she didn't intend to pay this month's rent, but that she intended to put the rent in escrow. So with that being said, would the court entertain an escrow order today?
I will, particularly since there was an indication that the payment for August was attempted to be paid, but was not paid. So how much is the monthly rent?
It is $2,055, Your Honor, and then there are utilities, water, sewer based on usage. There's a static trash fee of $5 and a service fee of $4, but the water, sewer themselves are based on usage.
Got it. All right, ma'am. Since you're saying to pay your August rent, I'm going to order that August rent be placed into court escrow. Right? That means you have to come to the court and you have to pay that into the court. You need to do that within 7 days of today's date. I'd suggest you do that by the 18th.
Understood.
And Your Honor, the
Okay.
total amount that was due for August, so the court is aware. I'm just taking out the court fees. Give me one moment.
Okay.
This is one of the most important legal moments in the entire hearing, because Judge Simpson orders rent to be placed into court escrow instead of being paid directly to the landlord. Escrow is not a reward for withholding rent, nor does it erase the tenant's financial obligation. Instead, it protects both parties while the court determines whether the repair complaints have legal merit. By requiring the money to be deposited with the court, the judge ensures the tenant demonstrates good faith while preventing either side from gaining an unfair advantage before the facts are fully examined. That is why documentation becomes absolutely critical from this point forward. Maintenance requests, photographs, inspection reports, and payment records could all influence the final outcome. Cases involving habitability often succeed or fail based on evidence rather than emotion, regardless of how compelling either side initially appears.
Total charge for August was $2,260.60. That includes the water, sewer, trash, and service fee. And then the September charge is $2209.08, and I can prorate that if the court desires.
Please do.
Times, what do we have? 18 days left. All right, looks like the September charge would be $1325.45.
All right. So 2260.60 and then 1325.45.
2260.60 and then 1325.45.
Okay. All right. Ma'am, I need you to deposit with the court. I'm going to order escrow at this time, given what you said regarding the rejection and payment and everything. So you'll need to provide to the court. Let me try to do my math here. Or paid to the court, $3,586.05.
And Your Honor, I can
Got that,
prepare
ma'am?
an order to that effect, and I'll indicate that if this case proceeds into any additional month, that it would be due within the ordinary course.
Yes, ma'am. That'd be fine. All right. So I need that within 7 days of today's date, okay? Ms. Caldwell?
Thank you. Thank you, Your Honor.
All right. And so that you're aware, that amount would need to be paid to the court in cash. Okay.
Gotcha.
So that there's no misunderstanding and you come all the way up here with that. I will then adjourn this matter to September 19th, 2025. Ms. Caldwell, that's an in-person hearing at 1 p.m.
Thank you, Your Honor.
All righty. Thank you.
Thank you.
Today's docket demonstrates that housing court is rarely as simple as unpaid rent versus eviction. Judge Simpson consistently balanced compassion with accountability, giving tenants opportunities to resolve their cases while also protecting landlords' legal rights. Some defendants received additional time because they showed a willingness to cooperate. Others were instructed to provide written evidence supporting claims of unsafe living conditions. In the final case, the court required escrow payments, ensuring disputed rent remained secured until the underlying issues could be properly evaluated. None of these hearings produced a final victory today. Instead, they established clear legal obligations that every party must satisfy before the next appearance. That is an important reminder that preparation and documentation often matter more than emotion in court. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and do not forget to subscribe for more jaw-dropping courtroom breakdowns.